Nowhere is the protective force of the Fourth Amendment more powerful than it is when the sanctity of the home is involved. Welcome back to Lost Touch channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. If you're new to the channel, every Wednesday we go into a deep dive on one criminal case, and every Friday I give you some of the big news in the days that happened prior. Today is Wednesday, so we're going to jump into a criminal case involving officers walking into the curtilage of the home, peeking through the window, seeing a pipe and some marijuana, drawing their weapons for whatever reason. When they see the owner of the home through the window, they announce their presence, get the owner of the house out of it, arrest him, handcuff him, put him in the squad car, and then they proceed to search the house, where they find weapons and some ammunition. Now, the owner of the house says that his Fourth Amendment rights were violated when the officers searched the home, and he tries to suppress all the evidence found inside the house. Before we go on and see if he succeeds, I want to thank you for watching me on YouTube, hitting that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of my merch, including the Do Not Arrest This Person t-shirts, stickers, and some other items. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we'll be discussing United States versus Fuentes, a very good case because it gives us an opportunity to discuss a lot of Fourth Amendment issues. Before we go on, let me give you some factual background. First things first, Mr. Fuentes is a felon. He has a number of convictions, which consequently makes him a prohibited person from possessing firearms. Now, at some point, there was a disturbance at Mr. Fuentes' house. Police arrived. Mr. Fuentes' father told the police that Mr. Fuentes has been high on methamphetamine for the last 3 days. During this incident, officers walked around the house and they saw some firearms, including one firearm they believed was stolen. Mr. Fuentes was arrested but later released. The reason I tell you this is because the search at the house at that point is not the issue. Nothing in this case discusses that search, and presumably there were no issues, at least legally speaking. About 6 weeks later, 3 officers decided to visit Mr. Fuentes again at his residence to quote-unquote interview him about the stolen firearm. Now, the officers didn't think Mr. Fuentes was the one that stole the firearms. In fact, they believed it was Mr. Fuentes' father who took the rifle. Now, when they came to the house, 3 officers were all wearing plain clothes. They were not in their uniform. They also didn't announce to anybody that they were the police. When they came up to the modest Mr. Fuentes' trailer home, they walked a narrow path to the front door. One of the officers went up 5 steps to the porch right in front of the front door, and 2 officers remained down below. He knocked on the door, but nobody answered. A few minutes later, he heard some noise from inside the house. Now, he didn't hear anyone come up to the front door, so he made a decision to walk down the 5 steps, through the grass, and peek into the living room window. Now, his face was about 6 inches from the window. He looked inside and saw a pipe and some marijuana in the pipe. Now, he kept standing there. He didn't see Mr. Fuentes. A few seconds later, Mr. Fuentes appeared in the window. I guess it startled the officer. The officer drew his firearm and ordered Mr. Fuentes out of the house. Mr. Fuentes grabbed the pipe, ran down the hall in the house and through the back door. Now, because there were two other officers, the house was surrounded, so he was met by two other officers in the back. The officers ordered Mr. Fuentes to the ground at gunpoint. He eventually complied. They put him in handcuffs. The officers then heard a male voice coming from the house. Somebody inside yelled out, "This is not my home." The officers ordered that individual to walk out of the house. Mr. Fuentes actually yelled it out as well. He told that individual to get out. The officers then handcuffed both individuals, Mr. Fuentes and this second person, took both of the men to the squad car, placed them inside, and then the officers decided to do a protective sweep by going inside the house and walking around. They didn't see anything inside. They walked out of the house, and at this point, they told Mr. Fuentes his Miranda rights, and then they tried to get consent to search the home again. They made 3 attempts. Twice, Mr. Fuentes told the officers that he does not want them to search the house. On the 3rd question, Mr. Fuentes complied and said, "Let's do it. Let's just do it." Well, later, Mr. Fuentes explained that he thought it didn't really matter whether he agreed or not, because he did just see 3 officers go into his house and walk out of it. So he didn't think that consent was really necessary. He thought the search was already happening, and when they asked him to search the house again, he didn't think anything of it. So he agreed. At this point, the officers went back into the house, searched it again, made a more thorough search, and now they found some firearms, ammunition, drug paraphernalia, and some other items. Mr. Fuentes is charged with a number of felonies, including being a felon in possession, but he says that his Fourth Amendment rights were violated when the officers searched the home, and even when the officer looked through the window. He says that that itself was a violation as well. Before we go on, let's talk about the Fourth Amendment. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Nowhere is the protective force of the Fourth Amendment more powerful than it is when the sanctity of the home is involved. Accordingly, it is a basic principle of the Fourth Amendment law that searches and seizures inside a home without a warrant are presumptively unreasonable. This presumption may be overcome, however, if the government can show that the search falls within one of the carefully defined set of exceptions. The warrant requirement is subject to certain reasonable exceptions because the touchstone of Fourth Amendment is reasonableness. Let's begin our Fourth Amendment discussion with the legality of the officer's observation of the marijuana pipe through the window. Now, it is undisputed that the Fourth Amendment protects your home. We just mentioned that. But the same protection is extended to the area that's immediately surrounding your home. That's called curtilage. If you're interested in curtilage and the legality surrounding the Fourth Amendment and that area, I encourage you to go on my channel and search for this word, curtilage, after you watch this video, and you will see at least a dozen cases that I've previously discussed on this topic. I have about 400 videos now on my channel. Can you believe it? 400 videos. So there's plenty of it for you to look through and research. But back to curtilage. Officers are permitted to go into that area, to make their way to the front door, knock on the door, and try to make an honest conversation with the owner or the occupant of the home. That is because we expect officers to behave in the same way that the general public would. Any individual would feel free to walk onto your driveway or walkway to your front door and try to engage with you. Now, of course, if you put up fencing or do not trespass signs, legally speaking, some things will change. But the way we have the setup here, the officers were permitted to walk on the path, go up the 5 steps, onto the porch, and knock on the door. Now, the Ninth Circuit said that officers are also permitted to walk around the curtilage and try to knock on the side door or make an honest attempt to find the occupants of the home if nobody answers the front door. But here the court says there's a sharp contrast to what is permitted. Here the officer walked up to the window. He was nowhere close to any point of entry of Mr. Fuentes' house. Instead, he peeked inside the window. That is very different than trying to make a conversation with the occupant. And usually, if the officers are legally allowed to be in the area, anything they find that's incriminating can still be used against the individual in trial because we have what's called a plain view doctrine. Anything that's visible to the public, the officers are permitted to look at that item too. But here, the court says the officer was not legally allowed to be at that area. He was not permitted to have his face 6 inches from the window. And so when he saw that pipe and marijuana, even though it was in plain view, he has to be in a lawful vantage point. And here he wasn't. And so the court says this initial observation came as a violation of the Fourth Amendment. And of course we can stop here, but let's talk about the protective sweep that followed next. Even if the detective's initial observations of the marijuana pipe were lawful, the detective's protective sweep was impermissible because there were no specific articulable facts indicating that other persons were in the residence who might pose a threat to the officers or destroy evidence. And what about the exigent circumstances? Well, exigent circumstances exist if law enforcement officers have probable cause to believe a crime has been committed or is being committed, and a reasonable belief that entry is necessary to prevent physical harm to officers or other persons, the destruction of relevant evidence, the escape of the suspect, or some other consequence improperly frustrating legitimate law enforcement efforts. The court says there was no exigency here because the officers created their own exigency by illegally looking through the window. And of course, the protective sweep was also not permitted here because by the time the officers are conducting the protective sweep, Mr. Fuentes and the second individual are both in handcuffs and inside the patrol vehicle. So there are no facts to indicate that anybody else would be inside the house who would pose a danger to the officers. The court further says that if we permit officers to conduct a protective sweep in this situation, then the officers would always be permitted to search the home if the individual is arrested outside of the house but in proximity to the home that's close enough. And for that reason, the protective sweep was not permitted and in violation of the Fourth Amendment. And finally, for the last topic of consent, it is well established that under the fruits of the poisonous tree doctrine, evidence obtained subsequent to a violation of the Fourth Amendment is tainted by the illegality and is inadmissible despite the person's voluntary consent, unless the evidence obtained was purged of the primary taint. Where the consent to the search is preceded by a Fourth Amendment violation, the government bears the burden of demonstrating that the consent is not only voluntary, but also sufficiently an act of free will to purge the primary taint. To determine if the evidence is sufficiently attenuated from the initial violation, we usually look at 3 factors. The temporal proximity, meaning what is the time difference between the violation and the consent. Second, the officer's intent. And third, any sort of intervening circumstances. Well, here, there are no intervening circumstances. We know that the officers were trying to get consent to search the home because they didn't have a warrant. But the most important factor here is, of course, the temporal proximity. The officers seek the consent immediately after getting Mr. Fuentes out of the house. They didn't wait any time. And in fact, because Mr. Fuentes just saw 3 officers walk out of the house, when they sought consent, Mr. Fuentes believed that his consent was not even necessary because he believed the search was already occurring. And for that reason, there is no valid consent in this case. I hope you've learned something about the Fourth Amendment here, consent, and some of these other big topics that we discussed, including curtilage and how the officers are permitted to walk onto the curtilage, but they're not allowed to go and look through the window to see if there's anything illegal inside the house. If you like this video, if you learned something, please give it a thumbs up, subscribe to my channel, share it with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. It really helps. In fact, this is going to be your July challenge. How many times can you share my channel with your friends and family? You might get a huge prize for it, a huge reward, or at least a thank you from me. And finally, if you want to support this channel, consider going to loststash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, stickers, and some other items. Thanks for watching.